8:30. Christine, will you, actually, Dr. Weston, will you do our invocation?
All right. Heavenly Father, in our hearts we plan our course, but we pray that you establish our steps. I pray that we seek you for advice and let us not make decisions based upon what we know, but let us act based upon your wisdom. Please guide us, Lord. We place this meeting in your hands. We place our hearts and our minds in your hands so that you may direct us. In Christ's name, amen.
Amen. Christine, will you call roll, please?
Yes, sir. Vice Chair Tom Butler, Dr. Ray Callis,
Present.
Dr. Gary Wesson,
Here.
Commissioner Helen Collier, Commissioner Nora Castaneda, Commissioner Lori High, Chairman Rick Figueroa.
Weston, will you do our invocation?
Yeah.
Thank you, Christine.
Mr. Chairman, is it okay if we excuse the commissioners that can't make it today, please?
The motion,
Second.
all in favor, say aye.
Aye.
Opposed? Motion carries. All right, we have a quorum, so for those of you that are here in person, which is extraordinary, by the way, great to see you guys. The audience must remain quiet because there are microphones in the ceilings and they're very sensitive and they can pick up your whispers. And also make sure your cell phones are turned off, if you don't mind. We're going to go to item C, if you don't mind. The recognition of William Kuntz. Mr. Kuntz actually was the executive director when I first started. So in times like this, I always want us to remember that this isn't a token moment. It's a recognition moment. And I think the difference is this, right? We stand on the shoulders of people who have come before us. And Mr. Kuntz is one of them. And when I came in, I'll give my 2 cents and I'll let Mr. Mendez do. But when I came in, I felt like a kid that didn't know what he was doing. And every time, people would say I'm still that kid, but that's not the point. But every time Mr. Kuntz held my hand and walked me through the process diligently and with patience. And it was astounding at the respect this man has had in the Capitol, which few have garnished the amount of respect this man has gotten in the tenure here at TDLR. So my hats off to you and his family.
Mr.
Chair
Chairman,
recognizes
Commissioners, Mike Harrisman, Executive Director. Let me tell you, this is a celebration time, but it's also a time to really reflect back on Bill Kuntz. When I began to start thinking about what I wanted to say, it became very difficult for me, not because I didn't have the words, but because there was so many words to say about Bill and the abundance of who he was. I want to thank the family for being here. Marcia, thank you so much for showing up. And of course, the children are here with them also, so we appreciate y'all being here. But I hope that you can gather from this just a small token, just a small piece of the impact that Bill had in this agency. And not only this agency, but you think about it in the entire state of Texas, the impact that he had on the 30 million people here. It's pretty astounding when you start thinking in that respect. I met Bill in 2005 when I first came on, and he was kind of the same way. He took me under his wing, and he began to start kind of showing me the ropes, telling me what's going on. And he was very patient with me, which I needed a lot of that. And but I can tell you through the course of time that I was with Bill, he pretty much solidified a servant leader for me. Because when you start thinking about the qualities of a servant leader, you think about somebody that's empowerment. And Bill did that. He actually allowed others to be able to be empowered in their decision making, their thought process, and he helped them along the way. That was a mentor in him. And so that quality that he had as a servant leader of empowerment really reflected every single day of his life and everything that he did. Another one you look at, a characteristic would be accountability. And we knew that Bill held you accountable. I mean, you'll see some things start flying up here on the screen a little bit, but we're affectionately calling Billisms because he always had a saying. And one of the sayings I remember about his accountability is, I pay you to show up to work. That's how he made you accountable. You're here, I'll pay you, but in the same respect, I'm looking for work out of you. And because of that, because he was very straightforward and honest, people produced and they were efficient. He ended up growing this agency, the model efficiency of the agency. So, yeah, and as you see the screen popping up, he had some really great things. Those were Bill's angels right there. The other thing that he was able to do was numerous times he was able to stand behind you and work with you. I can't tell you countless number of times that Bill would stand back and let others take the limelight to be shown. And in my time that I was with Bill and knew him, he would always tell me about a particular person. Mike, let me tell you what so-and-so did. And he would talk about their achievements and what they did at the legislature, what they did on this project, what they did in, a report or that had to be submitted to the LBB or the governor's office. He would showcase all those. So he always knew to stand back and let others shine. And that was the testament also of a servant leader of him. And more than anything else, Bill was authentic. He was genuine. He was compassionate. I can tell you that I know this not only on a professional level, but also on a personal level and a private level. Because I was fortunate to be able to go to Bill's house sometimes, and Marcia is aware of this, but we would just sit there, we'd have a steak, he would cook a steak, he would cook seafood. We would sit there and have some wine and eat. But then I would spend the night there, and he and I would go until all hours of the night just talking and visiting. We would just have that, we built that relationship with each other. When I took over as the executive director, was selected to be the executive director by the commission back in the, I called Bill, and he congratulated me, and I told him, I said, Bill, I said, I need you around, Bill. I need to be able to tap into you. I need your wisdom. And he told me, he says, Mike, you'll be fine. I said, well, I'm not saying I'm not, I'm just telling you, I need you around. I'll survive. But he was endeared by the legislature. Everybody loved him. Everybody wanted to know him. Everybody wanted to be around him. And the new legislators wanted to say that they met Bill Coots. They wanted to be able to tell other representatives and senators, oh yeah, I met Bill Coots, because he was that endeared at the legislature. So we're fortunate that we had an executive director like Bill Coots. We're fortunate that we were able to establish this agency because of his leadership and his vision for this agency. The core values that you see at TLR at this point in time is pretty much an epitome of who Bill was. And so he survived the agency by having those core values that are passed on to everyone. So everyone talked about the accountability, the respect, teamwork, communication, and that was Bill. So this is just a very small token of the love that we want to show to the family for Bill and what he did. If you're looking at the screen, one of the famous one he had is, I'm going to be in charge, not in control, which is kind of how I feel sometimes around here, around Kaiser. So, but he had some great sayings, wait to worry. And that's probably one of the best ones that I think that I carry with me where I go. I actually tell that to my children now. When things are happening and things are going tough, I just tell them to wait to worry. Because it's at that point in time when things happen that you actually have time to be able to start worrying then. But until then, just wait, sit back and see what happens. So he was a great man. He'll be missed, but more than anything else is that he left a living legacy in this agency because of what he's done. So we do have a couple of things. I'm not sure if we want to open up to other speaking. We do have a couple of gifts and things that we
Why
want
don't we
to
postpone on there just for a second? We'll do that. Under the restriction that he will not sing, I will throw a gavel at you. Chair recognizes Mr. Francis.
Mr. Chairman, do we come up here?
Yes, sir.
All right. Thank you so much. Welcome aboard, Commissioner. You came at the right time. Got a new boss there, guy. It's good. It's good. The old guy was not that very good. Mike covered a lot about who Bill is, and the chairman even touched about the shoulders that we stand on. It goes down to the nails. It's not just the exterior. It's not just the lights. I mean, Bill was a man of detail and vision. And that's something he always impressed upon me, treated me like his son. In fact, every day we leave work, love you, son. And we meant it. But Bill was all about vision. He always said, Brian, if you're a leader, you have to have vision. And it has to be something that can't be obtained. It's got to be something you're reaching for, because a lot of organizations today will set a vision, but they're really just setting a mission statement, and it's something that they get to show at the end of the year they did. That's not a vision, because you're not reaching. You're just doing your day-to-day work, but a vision is what drives you. And if you think about TDLR today, and Mike will agree, and Kaiser and the rest of the leadership team, we're just shadows of his leadership. And we just took a spot that he had already laid out thing. Yes, we put our little touch in there, our little flourish in there. But at the end of the day, his wisdom, and he was crazy. Bill Coons was crazy. Don't believe all the hype about the niceness of Bill Coons. Bill Coons was aggressive. He was a nasty fighter. He was a brawler. He was a brawler when you needed to be. And Bill Coons always fought for his agency. Every day fought for his agency. I would hear him taking the calls from Mike when he was the chairman at the time, and Frank Denton and Elliot McConnell and Commissioner Figueroa, and this. You could see him working the agency, working the mission, and then following our vision. And he would sit back and he would let folks shine, and he would grow people. The first book that Bill read for the agency was The Death of Common Sense. Our book club started day one with Bill Coons. The chairman of the House Committee on Appropriations said, "This is what your agency lacked. And now that you're in the seat, I want you to show some common sense." And Bill gave that book to all of his leaders to read. That's the man he was. He built a learning organization, an agency that continues to challenge itself, continues to push the envelope, doesn't stand timidly in the corner, doesn't look like the rest of the group, is not one of the crowd, but one agency that's willing to stand out and do what's right, and do what's hard, and do what they think is that's not possible. Bill's kids are here. His wife is here. They got to see him, unfortunately, in his Speedos. He will tell you about his Speedo stories. He, as he says, dispatched a deer in his Speedos one day in the river. That's Bill Coons. He shot a raccoon with a blowgun in his backyard, handed to him by his wife, Marcia. That's Bill Coons. He's jumped on toilet seats. That's Bill Coons. He's also changed the face of state government forever. He's changed the face of state government forever, and we miss him. But we are so happy that he's with his dad, and he's healthy, and he's vibrant, and he's living up there now, and living in our hearts. So we're gonna miss him. Mr. Chairman, how much more time do I have? I got about 20 more minutes. I'm gonna wrap it up, but yeah, it was just an honor. It was an honor to watch him move and to watch him do his thing. One last story. We were desperate for some money, and so we had an appropriation piece that we had to get, and it wasn't a lot of money, but it was big deal back then. And so the chairman of our subcommittee, Representative Allen, he was avoiding Bill, because Bill was hounding him every day. He was calling him. And I called Bill baby. You may not want to call that man so much, but he was calling him every day. So he knew that Allen had a hearing at 7 a.m. So Bill and I went to the Capitol at 6:30 that morning. And sure enough, we come in the Capitol, and Bill sees Allen's aide, and the aide sees Bill. So the aide tries to turn the corner, and Bill throws his suitcase down, and he's sprinting in the hallways, chases the man into the restroom. Bam! I know you're in there. What's the deal on our rider? And he corners the guy, and the guy finally comes out the restroom. He's like terrified. The best thing about this story is that 10 years later, we're talking to the aide, we're interviewing him for a job. And he tells the story of this crazy man chasing him in the Capitol, and Bill's like, "Oh man, that's just nuts." And the guy says, "It was you." It was the greatest story ever, but that's Bill Kuntz in a nutshell. He will fight for his people, and he fought to build this place. And we are all fortunate to benefit from his efforts. Thank y'all for honoring such a great man. Appreciate you.
Thank you, Mr. Francis. As usual, you're a masterful story. So I appreciate that. Could I ask the Coons family to come up, please? If you don't mind. Mike? We'll come around y'all. Thank you, sweet. Bless.
Somebody help Mike.
He got an engineering degree.
Nothing changed with my eyes. So.
Yeah.
Okay. So what we have here, wonderful family, is recognition from State Representative Simber Thompson. Certificate signed. We have a flag that was flown over the Capitol.
Oh, wow. Thank you.
Texas flag. And this wonderful print. And it is a blip on what your husband gave us. But make no mistake about it. Our honoring to him is not these gifts. Our honoring to him is what we continue and the legacy and the efforts and the pain that he took to make sure what I call TDLR, a quiet giant. Because when we work well, nobody notices us. But when something messes up, everybody in the world pays attention. But he was the head of the quiet giant. So thank you, ma'am. Thank you for sharing your blessing of a husband.
He
with
loved
us.
every single minute of it. Every single minute.
Would you like to say something?
No.
I just want to thank y'all for taking this time to honor him. We all loved him. We shared him willingly with this family. And I know he considered y'all family as well.
Thank you.
Thank you for sharing.
Thank you.
We'd love to have a photo with you. And Mr. Francis, will you please come up? You pop. Come on. Come on, pictures. We'll be on video.
Sure.
Put you in the middle. We're taking pictures when I have a conversation. Thank you. Thank you, ma'am.
Yeah.
Thank you very much.
Shoot.
Hey, that's
Okay.
Yeah.
Okay, all right. Thank you guys again for your patience on that. Thank you, Commissioner. You need a break?
Let's take a break.
Okay, all right, I tell you, we'll take, it's, 8:50. Well, 8:55, we'll reconvene on 5-minute break. Go to open, I guess, public comments?
Yes, sir.
Right. Okay, we're gonna do public comments. We accepting public comments in writing in person and by video conferencing call for those who submitted requests in advance to speak to commission. Commissioners received 2 written comments and 0 video conference comments, and we're gonna have 1, and so we're gonna ask Stacy Kirby, is that right? Go ahead and proceed. I'm gonna read you some instructions, Ms. Kirby, and then we can go from there, okay?
Certainly.
Excellent, thank you for being here, by the way.
Thank
So,
you.
okay, please state your name and who you represent. You have 3 minutes to speak. Christine will be keeping time. Please understand the commissioners are not allowed to ask questions or engage in a discussion with you about anything that's not specifically on our agenda. Please also understand that the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be decision makers in the case. You understand?
I do.
Perfect. All right, you have 3 minutes. Go ahead and go.
Thank you. My name is Stacy Sutton Kirby. I'm the Director of Government Relations for the Texas Humane Legislation Network. We're a 45-year-old animal welfare nonprofit that focuses exclusively on policy, legislation, regulation concerning Texas animals. THLN has been following the licensed breeder law and licensed breeder program administered by TDLR since the law's inception in 2011, and we are dedicated to that program's success and that law's success. First, I commend you for continuing the program while the COVID-19 pandemic presented enormous operational challenges. We're especially grateful to those who conducted on-site inspections to ensure dogs and cats under your purview were receiving adequate care under Texas law. I'm here today because it's important to note that while TDLR continued doing the job as best as could be done by continuing with inspections and finding violators, the federal counterpart to the program, the USDA, went the other direction. The USDA is tasked with licensing, inspecting, and finding Texas breeders that are their licensees who have 5 or more breeding females and sell dogs to brokers across state lines via online sales shipments, anything that falls under the federal purview. In 2017, the USDA rewrote the inspector's manual and failed to fill vacant inspector positions. Instead of citing breeders, conditions previously classified as violations became teachable moments. Before 2017, USDA inspectors reported close to 2,000 violations annually. In 2018, inspectors recorded 280. By 2020, that number declined to just over 150. In 2020, despite Texas having the 8th largest number of USDA licensees, USDA statistics showed they were only monitoring about 25% of their Texas licensees. I'm pointing this out because had it not been for TDLR continuing to do licensing and inspections, there simply would be no meaningful oversight of the large-scale commercial dog and cat breeders in our state. In June 2021, the Office of Inspector General report showed the USDA does not have reliable data on USDA licensees, does not follow up on complaints, and worse, had no consistent procedures for enforcement actions and documenting those actions. Unfortunately, this huge step back, how am I doing, Christina?
You're good.
Unfortunately, this huge step back by the feds coincided with a 40% increase in puppy sales. The pandemic pet boom combined with the lack of federal oversight means Texas needs TDLR and the licensed breeder program more than ever to ensure that people and pets are protected from unethical breeding operations. Again, I want to thank you for your hard work and dedication during the pandemic. And we look forward to supporting this program and its success while looking at ways to strengthen and improve the program. I do have a copy of that OIG report I can hand to you to make copies for the commissioners if you would like.
That would be great. We'd love to see. We thank you.
Certainly.
You having some eyes and ears out there is important. So thank you for your time, for your passion. We feel that. Thank you so much. All right, anything else, Christina? Any other comments?
No, sir.
All right, well then we're gonna go to item E, which is executive session. We'll now go into executive session to consult with our attorney under section 551.071 subsection 1 and 551.071 subsection 2 government code. Time is 9 a.m. After the executive session, we'll take a small break. We'll be back. Mr. Bowman, how long do we need?
Maybe 20 minutes.
All right, let's say we'll get back here in 9:30. We'll be back here at 9:30. Is that okay? Gives us 30 minutes to take a break. We'll pick up some action items from there. All right, thanks. We are back in open session. The time is 9:31. There was no action needed on executive items, so we're going to move on to item G. Authorized signatures. I'd like a motion for that, if you don't mind.
So moved.
Second.
All in favor, say aye.
Aye.
Opposed? All right, motion carries. Item H, minutes. Commissioners, you had a chance to look at the minutes. Any comments?
Yes, sir. Make a motion to approve.
All in favor, say aye.
Aye.
Opposed? All right, motion carries. Contested cases. If anyone's appearing in person for a case today, they'll call upon you when your case is announced. If anyone's appearing in a video conference today for a case, staff will provide them with information on how to connect with this meeting. We'll bring them into the meeting when we announce the case. So we're going to go to item 1 on our case, Griswold. Jessica Hurtado, is she online?
Good morning,
Yes.
Commissioners.
Can you hear me?
Yes, sir. Can you hear me?
Yes, ma'am. Yes, we can hear you, Jessica. Thank you so much. You have the floor. We don't have a licensee, do we?
No, sir.
Okay, Jessica, go ahead.
Good morning. Thank you, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. Before I begin, I do want to let you know that we were contacted by the respondent on late Friday afternoon, and because of a mail issue, they were not able to attend today due to the late receiving of the notice. However, the respondent did tell the department that they're not seeking a continuance, but they're going to rely on the Commission's decision. So with that, I'm ready to move forward.
Okay, go ahead.
Okay, thank you. I ask today that you reject the proposal for decision as written and deny Caden Cole Friswold's Class A Barber license application. On April 17, 2019, the applicant walked into a GameStop retail store with a weapon, which he used to threaten the employee with imminent bodily harm while he stole property from that store. Subsequently, over the course of the next 47 days, the applicant threatened 6 additional individuals working at different retail locations with that weapon while committing theft at those locations. In April 2021, the applicant pled guilty to 7 counts of aggravated robbery, a first-degree felony. The court placed the applicant on deferred adjudication community supervision for a period of 10 years, and the applicant will remain on supervision until 2031. The applicant submitted written evidence at the hearing expressing his remorse for his actions and addressing a traumatic event that occurred in early 2019. He explained that this event led to his mental health deteriorating, and according to the applicant, he committed the 7 aggravated robberies because he sought to feel empowered rather than to feel as if he were a victim. The applicant began attending counseling to address his mental state, and he also submitted multiple letters of character reference attesting to strong support for the applicant. Assaultive offenses are guideline crimes for the barber occupation because licensees have direct contact with the public in situations that have the potential for confrontational behavior. This is precisely what occurred in this case. Due to Mr. Friswold's desire to feel power over others and seek revenge for what was done to him, he sought out confrontations with 7 innocent people and threatened them with imminent bodily injury while using a deadly weapon. These were serious felonies that the applicant admits gave him an adrenaline rush, resulting in positive feelings and a continued desire to experience those feelings again. While the evidence shows that the applicant has made progress in addressing the circumstances which led up to his offenses, I have serious concerns that not enough time has passed for Mr. Friswold to establish a record of good conduct. The applicant committed 7 aggravated robberies a little over 3 years ago, and the applicant has been on supervision for only 15 months out of a 120-month sentence. Because I believe the evidence shows that the applicant may pose a continued threat to public safety, I ask that you reject the PFD and deny Caden Cole Friswold's application for a Class A barber license, and I'm available to answer any questions. Thank you.
Thank you, Mr. Tardo. I appreciate it. All right, Commissioners, do you have any questions? Okay,
Make a motion to reject the PFD.
you want to reject TFD?
Yes, the reason why, due to the fact that after Mr. Hurtado explained it to us very clearly, 120 months, this person has only been with 7 aggravated concerns for 15 months of 120 months. I don't see how you can argue against that.
Okay, is there a second to that motion?
I'll second.
Okay, Mr. Bowman, there's fact finding that we're gonna have to look at from this, right, correct?
Yes, sir. Mr. Chairman, this is Brad Bowman, General Counsel. I think in order for the commission to go a different direction than what the judge is recommending, we would need to look at maybe some findings of fact and conclusions of law. And it sounds like you're basing your motion on that there's not been much time that's passed since the offenses. So I think that goes to conclusions of law 11 and 12.
The time the crimes and plot suffered undiagnosed and treatment, was that right? Was that
Finding of facts 19 and 20.
okay? Okay,
And then there's a question, finding of fact 21 has to do with whether giving the applicant a license would give him an opportunity to commit further crimes of that nature. Doesn't sound like that's what you're basing it on. So 19 and 20, I think, would be the relevant findings of fact. So 19 and 20 findings of fact and conclusions of law, 11 and 12.
okay, I'm allow a little discussion on this, make sure that we get points of views.
Yeah,
Go ahead.
I'll start. Yes, sir, Mr. Chairman. The reason why I want to change finding of fact 19 and 20 and the law of 11 and 12 is due to the fact that Mr. Hurtado made it very clear that there's been 7 different accounts, 7 people attacked within the last 3 years. And he's been on quote unquote probation for only 15 months of 120 months. I think that we'd be doing Texas a disservice until this gentleman proves that he has definitely changed his behavior more than just a year and 3 months.
Okay.
Yeah.
Recognize Mr. Wesson, Dr. Wesson.
I'll do that too. I mean, I understand that.
Okay,
It just hadn't been enough time. And I think his deal was he wanted to feel a position of power or something. And, I'm like, well, he could go off in the barbershop too, I guess.
okay.
Yeah.
Mr. Hunt?
Yeah, I agree that not enough time has passed. I'm not sure of the length of time that should pass, but at this point, it has not even been a third of the time, not 20%.
Okay. All right. All right. All in favor of the motion, say aye.
Aye.
Opposed? Nay. Motion carries. All right. Thank you, Jessica. I appreciate it. You're staying on board. I'm sorry. You got the next one as well. We're going to Ms. Wing Mu Hong. Is that right, Jessica?
Yes, sir. Mhm.
Okay, go ahead.
Thank you, Commissioners. Jessica Hurtado, Enforcement Division. I ask that you adopt the proposal for decision as written and deny Wing Mu Hong's massage therapist license application. In May 2021, the applicant submitted an application for a massage therapist license, and a background check revealed that the applicant is ineligible for a massage therapist license due to her criminal history. After the department notified the applicant of our intent to deny her license application, she, through her attorney of record, requested a hearing at the State Office of Administrative Hearings. The department filed a motion for summary disposition with SOA, and the applicant's attorney filed a response to the department's motion. After considering the argument of both parties, the administrative law judge granted the department's motion and issued the proposal for decision without holding a hearing. The ALJ agreed with the department that the license application should be denied because Ms. Hong is ineligible to hold a massage therapist license. The applicant's attorney filed no exceptions to the ALJ's proposal for decision. This case involves the mandatory license denial provision in Chapter 455 of the Occupations Code, the law that regulates massage therapists, and that the Commission has consistently applied in prior cases similar to this one. I ask that you continue to consistently apply the law in this case and adopt the PFD as written to deny the applicant's massage therapist license. And I'm available to answer any questions. Thank you.
Any questions, Mr. Cotter?
No.
Okay, I'll entertain a motion.
Make a motion, due to the fact that we've talked and litigated many of these cases, that we support the PFD.
There's a second.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. All right, going on item 3, Natalie O'Leary. Can you hear us?
Good morning, Commissioners.
Good morning.
My name is Natalie Olvera. I'm a prosecutor in the Enforcement Division. This case is a combination of 2 separate vehicle storage facility, VSF cases, with a total of 3 violations against the same respondent, Belton Collision Center, and I don't believe that he is appearing today at all. I am requesting the Commission to affirm in part the proposal for decisions, PFD, and amend in part the PFD while assessing a $2,000 administrative penalty. The first VSF case involves 1 violation. The VSF failed to keep vehicle documentation within the requested 2-year statutory timeframe. A complaint was received by the department alleging respondent illegally disposed of a 2005 Dodge. A department investigator requested the respondent produce all documents related to the tow, storage, and sale of the Dodge. The respondent confirmed they did impound, store, and sell the Dodge, but could not produce any of the documentation on the vehicle. I requested an administrative penalty of $1,000, which the ALJ affirmed was an appropriate minimum fine for the violation. I'm requesting the Commission affirm this part of the PFD. The second VSF case involves 2 violations, one violation of hiring an unlicensed VSF employee, and 1 violation of failing to drug test the employee before employment. A department inspector testified during an periodic inspection. He observed the respondent's employee working behind a desk and proceeded to question the employee about her job duties. The employee stated she was employed by the VSF and her job duties included working on vehicle release documents and sending out notification letters. Respondent also stated the employee's duties were to collect payment on vehicle releases and the employee had access to all VSF documentation. The inspector searched the department's licensing database and discovered the employee was not licensed to work on VSF matters. Both the employee and respondent confirmed to the inspector the employee was not licensed by the department. The inspector also testified to questioning the employee if they had ever been required to take a drug test before their employment began as required by the department's VSF rules. The employee stated they had never taken a drug test either before or after their VSF employment began. Respondent also confirmed the employee had never been drug tested. During the hearing, respondent testified the employee answered phone calls inquiring about the VSF and impounded vehicles. Respondent also testified the employee would help him with vehicle releases, but then disputed his earlier statements about the status of his employee. Respondent then testified the employee was employed by his body shop, not the VSF. Based on the employee's own statements of being a VSF employee, performing all her job duties involving the VSF, and the inspector's evidence, I argued respondent was responsible for the violations of having an unlicensed VSF employee and failing to drug test them. Each of those violations carried a separate $500 administrative penalty. Despite the evidence presented, the ALJ disagreed with my position. I'm requesting the Commission amend this portion of the PFD and adopt my revised findings of fact and conclusions of law as stated in my exceptions filing. In total, I'm requesting the Commission accept the PFD in part, again affirming the respondent failed to keep the vehicle records within the required time frame, and amend in part stating respondent is responsible for the 2 violations of hiring an unlicensed VSF employee and failing to drug test them. I've included proposed language in my exceptions filing. I'm also requesting the Commission to assess administrative penalty of $2,000 for the 3 violations, $1,000 for the first violation, and $500 for each of the 2 remaining violations. And I'm available to assist with any changes you may like or answer any questions.
Thank you, Ms. O'Leary. Any questions, Commissioners?
I don't have any questions for now.
Anyone? All right. Take a motion.
Before I motion, to explain to the commissioners, after reading the findings of facts and the law of this whole case, I feel strongly that the ALJ got it right due to the fact, when you look at the conclusion of law and finding of fact. So not saying that Ms. Olvera and the department didn't work well, I just feel strongly that we should support the first case and the $1,000 fine and support the PFD. That's what I was recommending.
Your motion. Accept PFD.
Yes, sir.
Is there a technical correction, Mr. Bowman?
Yes, sir, there is. Thank you.
You're welcome.
Brad Bowman. The style of the case, there was an error, so we need to correct that in the written word.
So moved.
Any amendment?
Yes, sir.
All right.
Second.
Second. All right. Any other further discussion? All in favor, say aye.
Aye.
Opposed? All right, motion carries. 50. Mr. Bowman. Oh, is parking compliance solution attorney here?
I don't believe, Mr. Chairman, we have heard from the attorney. What
Okay.
we had heard as of yesterday was that he had another hearing this morning and would be running late for this hearing if he could make it.
Okay, we're gonna push him to the very end, and then we'll have a discussion after that. Mr. Thielen, good to see you, sir.
Morning.
How are you this morning?
Doing very well. How are you?
All right, good. All right, Mr. Thielen, you have the floor. Item number 5, gentlemen.
Good morning, Commissioners. My name is Trevor Thielen. I've represented the Enforcement Division on this case. We recommend you accept the Administrative Law Judge's PFD and deny Michael J. Holland's Incident Management Tow Operator License application and his tow company license application, which he filed under the company name Bonot Towing and Recovery. Mr. Hollins applied for these licenses respectively in March and July 2021. The department proposed to deny both licenses based on his 14 directly related convictions, including 2 cocaine possession felonies, 2 marijuana possession misdemeanors, an aggravated robbery, a misdemeanor assault, a misdemeanor terroristic threat, and a number of theft or theft-related offenses. In 2017, he was convicted of theft 4 times. 3 of the 4 were felonies and involved the applicant stealing vehicles. In one of those cases, the applicant used a tow truck to steal 10 motor vehicles, towing them to a scrapyard and then using someone else's name each time at the scrapyard, and using a different temporary paper license plate on his same truck for each trip. In 2019, he was convicted of more felonies, 2 felony thefts of vehicles and 1 unauthorized use of a vehicle. The last of these offenses occurred when he was 43 years old. Drug offenses are a concern in towing because a licensee may use a truck or a company as a front for delivering drugs. Assault and robbery are a concern because a licensee must not react to confrontation with violence. And the theft offenses are a concern because a licensee might use a tow truck to steal property or vehicles, which is exactly what the applicant did again and again. Despite the letters of recommendation and the excuses the applicant gave for his offenses at the hearing, the ALJ agreed that the applications should both be denied. Enforcement recommends you accept that PFD. I'd be happy to answer any questions.
Thank you, Mr. Thielen. Any questions, Mr. Thielen? All right, I entertain a motion.
I'll make a motion. Do we need to remove the conclusions of law and support the PFD, Brad, or,
I don't think I'm listening.
I'm just making sure because whenever I read it, I just want to make sure my motion is correct.
Yes, sir. Mr. Chairman, it's Brad Bowman. The ALJ included discussion of a particular section of law 51.4012A, which has since been repealed. It had to do with the honesty, trustworthiness, and integrity standard for licensure. So that's not really necessary to address in this PFD. We're not quite sure why that's in there. So we would recommend removing the conclusions of law that have to do with that section. Does not change the outcome or the result in the case.
Sometimes I get lucky. So yes, I'm supporting my motion, please.
Is that technical correction? Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? All right. Thank you. Motion carries. Mr. Thielen. Andrea Diaz.
Morning, Commissioners. Trevor Thielen. With enforcement, I handled this case involving Andrea Diaz, a massage therapist who was licensed by DSHS in 2011. We recommend that you accept the administrative law judge's PFD and revoke the massage therapist license because the law requires you to do so. The statutes involved here are the same massage industry statutes you considered in the Lisette Martinez case, in the Hui Zulu case, in the Vicky Nguyen case, in the Zin Liu case. In each of those cases, the department's evidence activated a massage law which required you to revoke the massage therapist licenses of Martinez, Liu, Nguyen, and Liu. In each of those cases, the evidence also activated another massage law that made each of them permanently ineligible for a massage therapist license going forward. In each of those cases, DSHS unfortunately ignored or misinterpreted the clear direction from these laws, which have existed in roughly the same form since 1987, to grant and renew massage therapist licenses. Now that massage therapy is regulated by TDLR, this commission has followed the clear direction of those laws in the prior cases, and you must do so again in this case. This case comes to you the same way that the Nguyen and Liu cases did and how the Hong case did earlier today, through summary disposition. That means the ALJ agreed that the department's evidence required revocation as a matter of law and no hearing was required. The respondent opposed summary disposition, but the court determined that the respondent's constitutional arguments could not be considered in SOA and that the commission had no discretion over whether to revoke here. As in the previous mentioned cases, there is simply no discretion, like in a case based off of Occupations Code 51 or 53. This is a Chapter 455 case, and Chapter 455 requires the same end result as in those prior cases. You have no other legal option but to adopt the PFD as written by the ALJ. I'm available for any questions.
Thank you, Mr. Thielen. Is there a technical on this one, Brad?
Yes, sir. There's a typographical error in the license
Okay.
that we recommend.
If you have a motion, if you don't mind, add that. That'd be great.
I'll make a motion to make that technical correction in PFD as amended.
There's a second.
Second.
All right, any further discussion? All in favor, say aye.
Aye.
Opposed? All right, motion carries. All right, Mr. Thielen, item number 7.
Linda Ferriulo's case came before you last time, and the commission moved the case to this agenda to give her time to surrender the license voluntarily as she wished. That's been executed in the meantime. That case has been closed, so there's nothing else to present on Ferriulo.
Make a motion to dismiss the PFD.
There's a second.
Second.
All in favor, say aye.
Aye.
Opposed? All right, motion carries. Item number 8, Mr. Thielen, Jones.
Trevor Thielen with enforcement also handled this case at SOA. We recommend you accept the administrative law judge's PFD and deny Spencer Jones's apprentice electrician license application. In 2014, when he was age 19, the applicant committed 2 counts of sexual assault of a child and 1 count of indecency with a child by sexual contact. These felony offenses occurred on 2 different dates, and the victim was 15 years old. In November 2015, the applicant pled guilty to these offenses and was placed on a 10-year deferred adjudication probation in order to register as a sex offender. Assuming he continues to comply with the probation conditions, he will complete the probation in 2025. The sex offender registry lists his risk level as, quote, moderate. Enforcement examined the evidence in this case and proposed to deny the electrician license because sex offenses and offenses against children are directly related to the occupation. Licensees with sex offenses can pose a danger not just to customers or children present in the homes of customers, but also to coworkers who can be as young as 16 and still legally hold an apprentice license, work on these job sites. At the hearing, the applicant said in his opening statement that he doesn't think a licensing agency should be in the position of judging his fitness to work, even though that is exactly what the law has ordered TDLR and this commission to do. He then told the ALJ he did not have any witnesses to call and did not want to testify himself or introduce any evidence beyond the letters of recommendation he sent us and that we included in our evidence. The ALJ agreed with the department that a full unrestricted license was not appropriate given the applicant's criminal history, the fact that he's on probation for 3 more years, and, quote, the incomplete nature of the evidence concerning his rehabilitative efforts. There's a lengthy discussion as well about the possibility of a restricted license, which the ALJ ultimately agreed with the department was not appropriate in this case. I can go over those reasons why if you wish, but I recommend you adopt the ALJ's proposal for decision and deny the application.
All right, thank you, Mr. Any questions for Mr. Thielen?
So moved.
Is there a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed? All right, motion carries. Mr. Thielen, I think you're, Mr. Wall, number 9.
Trevor Thielen with enforcement, also handled the Wall case. We ask that you accept the administrative law judge's PFD, which recommends that you revoke Kyle Wall's apprentice electrician license and deny his application to renew that license. The respondent was granted this license in 2016. He had no criminal history until 2020. In April 2020, he was having problems with his girlfriend. When his girlfriend wouldn't tell him where she was, the respondent, who lived in Round Rock, suspected correctly that she was at another man's apartment miles away in Austin. He texted her, quote, "I'll be checking at the victim's apartment complex in Austin every morning and every night from now on. On my way there now, you better not be there. Get out of there while you still can." The man she was with later exited his apartment to check his mail. That victim told police that the respondent emerged from a hallway pointing a gun at his face and walking toward him. The victim said he batted the gun to the side and the two scuffled until the victim punched the respondent and the two came apart. Then the respondent shot the victim and ran away. Thankfully, the wound was not fatal. The respondent told a different story to the police later. After first denying he was ever at the victim's apartment complex, he then changed his story to claim he was there simply looking for his girlfriend, with his gun on him at the time. He banged on the victim's door but decided to leave, and then he was stopped when the victim opened his door and charged at him, leaving him no other option but to shoot the victim in self-defense. He continued to claim he acted in self-defense at his hearing. His self-defense claim is contradicted by the fact that he pled guilty to aggravated assault with a deadly weapon instead of presenting his self-defense arguments at trial. It's also contradicted by texts he sent to the girlfriend after the shooting. At first, he denied shooting the victim, saying, quote, "I didn't shoot him, but I will." Then he claimed the victim must have shot himself to get attention. He said, "If I shot him, he'd be dead. You know that." Finally, the respondent asked his girlfriend if she was with the victim romantically and wrote, "That's it. Now this dude is dead." Aggravated assault with a deadly weapon is a guideline crime for electricians because a person who is susceptible to violence in difficult or emotional situation may pose a danger to the public. The respondent took his gun and actively sought out a bloody confrontation against an unarmed man, and he sandwiched that assault between threats, intimidation, and boasts about how deadly he was. This happened just over 2 years ago, and he still has over 3 years of deferred adjudication probation left. We were unable to confirm whether he is complying with the probation through his probation officer, and the respondent did not put on any evidence or testify under oath during the case. There is nothing in evidence suggesting the respondent has grown or changed from the man he was 2 years ago. The ALJ recommended you revoke the license and deny the renewal. We recommend you accept the PFD as written. Are there any questions I can answer?
Thank you, Mr. Any questions? Motion?
Make a motion to accept the PFD as written.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carried. Thank you, Mr. Thielen. Appreciate it. Bowman, do you want to wait for this one to be at the end, or do you want to just go ahead and move for a continuance?
Mr. Chairman, we have not heard from the attorney. I just checked with my staff. So it's really up to the commission, how you want to proceed. We can wait a little longer. We can cover some other items in the meeting and see if he shows up and then make a decision at that point about continuing it, or you can go ahead and continue it now to your next meeting.
Tell you what, let's, commissioners, unless you guys want to go otherwise, I'm just going to give them another 30 more minutes and then we'll move from there. Is that okay?
We can come back to this.
Is that okay? Okay. What time do you have?
10:30 to be at the airport by 11.
Okay, well, that'll be the point. All right, let's move forward. Rules, Mark Guideline. Where are you? There you are. Item J. Mark, good to see you, sir. I can't hear you. I think you're on mute.
Sure was. Good morning to you.
All right, Mr. Gladney, go ahead, you have the floor.
Thank you. My name is Mark Gladney, Assistant General Counsel for TDLR, and I'm here to present this rule package for adoption that implements Senate Bills 916 and 1480 passed in the last legislative session, which pertains to the Court Ordered Education Program, or COEP, and that was formerly known as the Offender Education Program, OEP. Please forgive me if I mix up acronyms a little bit between COEP and OEP, because the program for a long time has been referred to as the Offender Education Program, and we commonly use OEP, but both OEP and COEP mean the same thing. Now, implementation of Senate Bill 1480 and these proposed rules, what it does, it modernizes the landscape of the court-ordered education program, which include the alcohol education program for minors, drug offender education program, the DWI education program, and the DWI intervention program, which now are known as endorsements under the terms of SB 1480. And we'll get into that a little bit down the line here. But it consolidates, the bill consolidates the program requirements that were previously found in other statutes like the Code of Criminal Procedure, the Alcohol Beverage Code, and the Transportation Code. And what it does is it combines all of these statutory requirements in the one chapter, Chapter 171 of the Government Code, for easier reference and efficient organization for licensees and the general public. And that makes it consistent with the manner in which we regulate and administer other programs. In keeping with the legislative changes, the proposed rules include amendments, including repeals and rule section renumbering within Chapter 90 of the COEP rules to provide greater clarity and implement the provisions of Senate Bills 181 and 1480 for starting with Senate Bill 1480, the modernization effort includes several important new changes for program providers and instructors in the program, such as authorization of online instruction to allow these court-ordered programs to reach persons throughout the state, which increases program provider business flexibility and promotes cost savings for instructors and providers. Previously, you couldn't offer these types of courses online. The participants, who are commonly people who have been sentenced by courts to attend these various programs for criminal violations, they had to attend in person. But now, program providers can actually offer these courses to these individuals online. So you could have a program provider that's based in Pflugerville, and they can actually offer these programs to anybody throughout the state as long as they comply with the rules and regulations we have set up for, say, a licensed online program provider. The next thing that the modernization does is it creates a unified provider license, which covers multiple locations, and SB 1480 eliminated the structure of the hierarchy they had between headquarters and branches. So if you're a provider and you have multiple locations providing these courses to people, now instead of having to get a license for each branch, we'll have one unified provider license. So if you're a provider with 20 branches, those 20 branches will now operate under one provider. This creates more efficient license administration for department staff, meaning it's easier to keep track of them, and it reduces costs to the state and licensees. We've also simplified the licensee structure, again, by eliminating branches and headquarters for program providers. And we've also instituted through SB 1480 new program fees for program providers and instruction. So Other changes that were made in line with SB 1480, we established eligibility requirements and minimum qualifications for licensed applicants, mandated minimum standards for online and in-person provider delivery of curriculum. We updated the rule terminology to include new license types introduced by SB 1480. Program provider structure changes and the court-ordered program endorsements that we talked about briefly. And the endorsements are basically just nothing more than the various courses that are offered under the COEP umbrella. So in effect, what you'd have is you would have a COEP general license, whether you're a provider or an instructor, and whatever courses you wanted to teach to prospective participants, you would go and apply and qualify for that endorsement. So if you wanted to teach the DWI education course people, you would get that endorsement. If you wanted to do DWI intervention program courses, you get that endorsement and so on. The other changes in line with the modernization of the chapter include criminal penalties for violations involving certificates, program completion, and again, updating the rule language to remove repeal statutory references. The proposed rules in this rulemaking simply represent the first phase of bill implementation. There's much more to do related to this bill to complete the intent of the legislature. A subsequent rulemaking will complete the implementation of SB 1480, and that's going to include rule amendments on curriculum, program provider reporting, audits, and inspections and continuing education. Now, the proposed rules also implement 181, which is the drug offender education program, and that requires the department to work with DPS to jointly adopt rules for the qualification and approval of providers of in-person and online drug offender educational programs that are approved by the department. The rules were published by the Texas Register on June 10th. The comment period ended on July 11th. Surprisingly enough, no comments were received on this. Post-publication, staff noted a few minor corrections that were made to sections 90.1, 90.91, and 90.92. They're mainly for grammatical purposes to clarify content. And if some of you want me to go over those, we can do that if you have any questions on it. There's no advisory board for this program. Thus, these proposed rules go straight to the commission for final adoption. The department recommends the commission adopt the rule package as published with the changes I just noted to 90.1, 90.91, and 90.92 with an effective date of September 1, 2022. And that's all I have.
I appreciate that. Any questions? All right, I'll entertain a motion.
Make a motion to adopt the rules as amended.
Second, all in favor, say aye.
Aye.
Motion carries. Appreciate it. Thank you, sir.
Thank you very much.
Couldn't get a dyslexia plate in that one because I could hear like every fifth word. We need to work on that. I don't want to work that hard, Mike. That's still too difficult for me. Item number K on this. Wow. It's supposed to be good at seeing you in heart. Wow. Like you just put your nose in your ear, right? Item K, appointment.
Good morning, Commission Chairman. We have a really short one this time. Sometimes it can go on, Commissioner Hyde, for pages and pages. But today we just have a few of our truly faithful members who have effectively served their respective positions and careers, as well as the agency. For Dyslexia Therapists and Practitioners Advisory Committee, we have Ms. Robin G. Kauser of Fredericksburg. Ms. Kauser has been a member since we got this program, and she's very active in that community, so we appreciate her willingness to continue to serve. For Property Tax Consultants Advisory Council, we have W. Ken Parsons, Mr. Mitchell Katine. And then we have W. Ken Parsons. Mr. Katine is from Houston, Texas, and Mr. Parsons is from Dallas, Texas. And also they are members who've been serving currently, and we're just asking for reappointments. They attend the majority of the meetings and are very active, and that's why we seek them to continue to be a part of both this council and this committee.
All right. Commissioner Hyatt, basically, and Commissioners, I want to remind you guys, this is pivotal, right? We cannot understand all 40 licenses, so these advisory commissions are important. I look forward to getting names from you that you feel could be great. And if Mary will let you know those terms that are up or new appointees, I know they mostly do it for the pay, right? That's
We doubled the pay recently.
yeah, extraordinary effort.
Yeah.
Sounds good.
Same pay you get, so.
Yeah.
And so, but I just cannot emphasize enough how important it is to have these. So I entertain a motion.
So move.
Second,
Second.
all in favor, say aye.
Aye.
Opposed?
Thank you so much. I will notify them immediately.
Brad, I think for this, just allow the continuance, give the attorney, let's see, here, right here.
I have not heard anything, Chairman.
I think, commissioners, are we okay with giving the continuance?
Do we need a motion on that?
Yes, sir.
I think it'd be
Motion
good
to
to
have
have
a continuance on the parking compliance solution LLC case.
Right, that way we can go ahead. Is there a second? All in favor, say aye.
Aye.
Opposed? All right, if you'd let the attorney know, motion carried. Thank you. All right, executive reports.
Chairman, Commissioners, Mike Harris, Executive Director. I don't have much to be able to present to you. I think that everything that you probably know you receive from our weekly Executive Director updates that I send to you. So I do have a couple of things to let you know about is that we are now embarking on revisiting the vision mission statement of this agency. Kenny's group over at the Office of Project Improvement, they are embarking on putting a group of volunteers together from the agency, and they're calling it a DNA focus group that will actually look at the DNA of the agency and begin to start doing it. We're going to do it from the ground up. We're going to have our team members provide all that information so that they can develop and build the new vision mission statement, which will come from the 500 employees that work here at TDLR. So looking forward to that. We'll continue to give you some additional information on that. As I'm moving forward on my report, I think we're going to have a report from FCIC if that could come up. And also the state auditor, we were audited, I don't know if you've given that, but if you are, okay, yeah, if you want to just come up, I'll give you a little bit of information. I do want to talk to you about our e-inspections report that's coming out of the field inspections. It's a part of the sunset recommendation. And the ability for that is to be able to do some data collection and process in the inspection portion of it for the risk-based. So that one is moving nicely. I think they've actually implemented in the field. At this point in time.
We've gone live
Yeah,
with the
outstanding.
inspections.
so they're
Sorry
now
about the
live.
massage program.
Before you go, if you don't mind, is there anything I'm missing on the vote? Because we'll lose our quorum in about
I don't
15
think
minutes.
so. I think we got everything covered.
Okay, good, excellent. Okay.
So, and I'll go ahead and just turn it over and let Jessica present the FCIP, and then him will follow up, and then we'll be done.
You won't lose your quorum because that's my ride to the airport.
Good. Chairman, Commissioners, I will be very brief. Just a
Apparently
quick,
so.
I have no choice. Quick update on FCIC. As you heard during our last meeting, when we were together for LAR, the FCIC is doing astounding things. As of today, or as of actually the end of July, they have either prevented losses of 11.6 million or recovered almost $850,000. So they're at $12.4 million as of July 31st, almost 5 times their $2.6 million biennial budget. So they're doing great. They've taken almost 2,000 calls from law enforcement. That's in addition to working with law enforcement agencies throughout the state. They have very close working relationships with North Texas law enforcement agencies. They put together a task force with them, and they're building relationships throughout the state. So they're busy working, doing trainings throughout the state and building out intelligence bulletins and sharing their knowledge that they have. So those are the highlights, keeping it short, and we'll continue to keep you updated.
Commissioner, let me tell you something. There is nothing more irritating to a citizen of the state of Texas and this to happen, financial crime. So for you to, so I can't tell you, this is not about a little kid with a card. This is organized crime. These are high level and very sophisticated. And so I'm very proud of what you guys have done. And the center is an incredible center. I've yet to go, and I promise you I will go. And the efforts that are done, it is a center that's paid for itself multiple times. So,
Absolutely.
so I cannot applaud you more than what y'all done over there. I know it's a team.
It is a great
Great
team.
job.
Mr. Chairman, I'll tell you that we have plans to probably go up again in the next probably couple of months because we're making it kind of a quarterly visit to the FCIC Center. So if anyone's interested, then we'll make you aware of the plan of being up there and you can travel up and see the FCIC. So they'll be more than happy to show it off.
I'd love to go. Thank you.
Mr. Chairman, I also want to thank the executive director and the vice executive director for making a better chart. Whenever we were looking at it from the LAR, it was very confusing. And now, thank you very much for changing that. Appreciate it.
We're trying to make sure that we give you all the dashboards that you need. You'll probably notice it in the division reports that you have. We're trying to set a little more dashboards, numbers that you can see, a little bit clear cut. So we continue to refine that. So if there's anything that you say, we want to look at something different, just let us know. We'll make sure we go back there and refine that.
We've been working with Dark Cow, small words, nice pink colors. Okay, that's all I'm saying.
I'm the punching bag today because this vice chairman's not here.
All right. Emmett?
Thank you, sir. Mr. Chairman, Commissioners, we are undergoing 2 audits, as you know, one by the State Auditor's Office that began on May the 20th. They will complete field work by August 31st. A draft report will be provided by October 12th. And the report is expected to be released on November 4th. And this is a performance measure audit. It's been 11 years since we've had one of these audits. So we look forward to this outcome, and field work remains ongoing. The second audit we're going through is through our internal auditor for our fleet management program. And as you know, we have that as an exceptional item in our LAR. This audit began on June the 23rd. Field work remains ongoing, and we expect this audit to wrap up by the end of August. They initially expected an exit by July 22nd. That didn't happen. There's been a lot going on, but we expect both to wrap up by the end of August.
Excellent.
All right.
Great job.
All right. Thank you.
Tremendous.
I can tell you that along with the internal audit stuff, we got the kudos to Tony Kuyan, who's kind of the front person for that. He's doing a lot of work, and Yeoman's working that. He stepped off of the LAR process. Now he's working on the continues to do the SAO audit plus the Weaver audit. So Tony's been the front man for us in that respect. So we have to give a lot of credit to Tony. So thank you.
By the way, LAR, very, very short runway. Outstanding job. on doing that.
They did it fantastic job.
Outstanding job on that, right?
Yeah. As I mentioned earlier, they instruction came out July 1, and they said, oh, by the way, it's July 29. It's 4 weeks after that. And they dropped it right before July 4th weekend. So we had a long weekend as well. But I can tell you this dedicated group didn't wait. They began to start working on it immediately. And so I can tell you that with him at taking it and organizing it the way he did, it was a smooth process. I can't even say it was hurting cats because he knew exactly where everybody was at. Right. And he pushed them along the way, and he dropped them all together, and they all moved in one sync process to get to that final. That when we got to the end, I mean, they just put it together at that point in time. He did a great job. So him did a great job with the.
I'm gonna say, I'll second that motion.
That's a great job. I know it's under stress. Stress will cause hair loss.
He did a lot better than.
Be careful.
Appreciate that.
A little warning.
That's all right. Okay. And tooth loss. I've got to, yeah.
As well. So, thank you, Hammond.
Thank you. Appreciate it.
Mike, anything else?
Mr. Chairman, I believe we're done. We're done with the executive reports. So unless there's any questions for me.
Commissioners, anything else? October 18th will be our next meeting, instead of October 4th. Please put that down. Don't look at me like that, Commissioner.
I didn't, sir. I'm looking at my calendar.
I appreciate that. Look at your calendar. I'm assuming that's enough warning. We moved it from 4th, give it a little more time. So, Christine, I want to make sure the other commissioners know.
Yes, sir.
Okay. If there's a problem, I would appreciate you letting us know quickly if you can't make it, so that we can, if we need to adjust, we will. But if not, I know it's always difficult. Anything else? All right. I will entertain a motion to adjourn. So second. All in favor, say aye. All right. Please adjourn. I'll stay. Thank you, guys.